John, went away for college, Swarthmore and University of Pennsylvania, and had the opportunity to go clerk for very impressive federal judges and stay out east, like his twin brother did. But John chose to come back home here to Kentucky, and he started his career in Louisville as a young lawyer. Your second year in practice, John found himself in the Supreme Court of the United States as counsel in Brandsburg v. Hayes, which is to this day the most important reporter's privilege case ever ruled on by the U.S. Supreme Court. Shortly after that, John was intimately involved in drafting the open meetings law we're going to talk about today, and the open records law 2 years after that. I think it's fair to say John is the undisputed master of open records, open meetings, and defamation litigation in Kentucky. Every major case you read in those areas has his name on it, right at the top. He's argued countless cases in trial courts and in appellate courts across this state and in federal courts, establishing law for the press and the citizens, right to know what their government is up to. John has won every single award this organization gives out, I'm pretty confident. In fact, they now have an award named after him. And he's won pretty much every other press or First Amendment freedom award in this state, member of the Kentucky Journalism Hall of Fame. And it's all well-deserved. So it is truly my pleasure to be here today to introduce my colleague and my mentor and my friend, John Fleischaker. So I'm here to play traffic cop today. So I'm going to ask a few questions, John. So let's go back to the before times. It's the early 70s. You're a young lawyer. You just came from the Supreme Court in the Brandsburg case. How did we wind up in the General Assembly talking about the open meetings law?
I came back from the Supreme Court, and the next day I was in police court in Kentucky. So I think what happened, and I'm comfortable what happened, with the early 70s was a time of real change and activism in the United States. We had Vietnam War going on. We had the Pentagon Papers case, which was a 1971 case, I believe. We had a rebirth and a very strong civil rights era that was ongoing. And we had a situation where there was great distrust about government and government officials. And Watergate. Watergate was also going on at that point in time, a little bit later, but still in the 73, 74 time period. The KPA at that point was the Bingham family was very important in maintaining and encouraging the KPA, and the decision was made to try to start what was then going around the country, that is open meetings and open records, but under different names. The decision was made in 73 to start with open meetings with the idea that it would be easier to pass. There were a lot of reporters, and I can think of a couple by name, who really were against open records at that point. They thought that good reporters could get anything they wanted. They didn't need to have a law, and that this would shut off sources. They were wrong. They were wrong on all counts. But we got the commitment, the Binghams, I believe, got the commitment from the governor, who I think was Governor Ford at that point. And we started drafting. Now, this was 1973. I was a very experienced 27 or 28-year-old lawyer who really didn't know what he was doing, but I knew enough to start looking at the books and seeing what was on what other states had. And we put together the open meetings law, which was opposed, as were the open records laws, by two main forces. One, we always had opposition, and still do, from law enforcement and from people who administer law enforcement agencies. The second one, which really has surprised me for 50 years, is the opposition to transparency that is exhibited by most universities and colleges in this state, and as I understand it, throughout the country. The biggest opponent to transparency has always been colleges and universities. That has always surprised me, and it has turned out to be a great source of litigation, which I've enjoyed. Telling university presidents, no, I'm telling you what to do, you can't tell me what to do. That is, depending on which end of the table you're sitting on, either a great thing that I have or not a very good trait. So it really was part of the whole idea, Mike, that we were moving into a new era, and we really got started. We didn't know what we were doing, but we tried hard, and I'll get to it later, but after 15, 16, 17 years of working on it, we come up to 1990, and ended up by a circuitous route with an interim committee of the General Assembly to review it, and the result was that we strengthened the laws substantially. But we can get to that later.
Yep, we will definitely get to that. So I'm struck some things never change. We still have quite a bit of resistance from law enforcement and universities to a lot of stuff we do. But what was it like to actually go before a General Assembly that was open to transparency measures? I find that kind of hard to fathom sitting here today.
It probably would be hard to fathom, except in those days the governor dictated what was going to happen. I don't want to say it was the good old days, but when it came to that kind of stuff, it was the good old days. I'm not sure we could have gotten it passed. I know we couldn't get it passed in the current legislative environment, but Ford was a big fan of it and had committed to it, and we had the same kind of commitment from the next governor, Julian Carroll, and we had. So it really wasn't a problem at the legislative area. The problem was some of the negotiation that took place prior to that, but we got it done. We had much more negotiation, frankly, on the open records law with the state police and law enforcement really coming down hard on us. But we did something in the 70s that simply couldn't be done today, in my judgment.
Yeah. So let's talk a little bit about the original version of that law. Some of the key features that you all put in the original version were, the requirements of the minutes, schedules of regular meetings being published, the executive session procedures and the limitations on that, special meeting rules, and, some of the initial penalties that were in the act. Why did you think, when you were looking at it, why were those the areas you focused on? And maybe were there some things you all tried to get you couldn't get at the time?
I think there were two areas, there really were three areas that we should have focused on. One was the definition of a public agency. We didn't focus on that as much as we should have. A lot of correction went into in the 1990 situation on the definition of public agencies. The procedures, I think, are extraordinarily important, and nobody had them, nobody knew what to do with them. Nobody raised a question about it because they frankly didn't read it probably. They still aren't reading it. So we have, I think my judgment is that the procedures were an immensely important thing, and I think you would agree, Mike, that as we litigate this stuff, the procedures really have been a winning point on a lot of cases. As most of you know, when you run into public officials, they often take the position that it's their government, not your government. It's they can do what they want to do. What I find really interesting is that the more things change, the more they stay the same. Mike has ongoing litigation now dealing with so-called private cell phones and the use of cell phones to do text messaging and emails during meetings or in lieu of meetings. If you look at the definition of a public record, and this goes to records, in 1974, or 75 when that was drafted, it includes, in my judgment, cell phones. It includes electronic communication. Either the person who drafted it was extremely brilliant in including that. Most likely, in fact, the truth is, it was just plain luck. Because what we did was to take a variety of statutes and try to put them together. I had a partner in crime on the open records, and I know we're not supposed to be talking about open records, but he was also very involved in the open meetings, and that is a guy named Bill Cox, one of my favorite people. Bill has been dead for coming on to 30 years now, more than 30 years, but he was a terrific reporter, a terrific editor. When we were negotiating the penalties, we were sitting at the table and going around the table about how do you penalize, both for open meetings and open records, how do you penalize them? You know, fines, penalties, and Bill with a very straight face said, it should be the death penalty. He said it with a very, he had a very weird sense of humor, but the more I practiced in this area, the wiser I think he seems.
Guessing the governor didn't go for that back then, so.
Well, we would exempt certain people,
Yeah.
and they would go with the rest.
Yeah. So we will get back around to the ways that agencies use technology to circumvent meetings laws today, because you're right, there's a lot of that going on. But let's go back to some of the old-fashioned ways of circumventing the meetings requirements. So you had a case with the Jefferson County Fiscal Court immediately after the law went into effect. Tell us about that case.
We've talked about the procedure. I assume most of you know about the procedures to go into a closed meeting, to notify regular sessions, what you can go to a closed meeting for. And I got a call from the reporter. The four members of the fiscal court of Jefferson County were meeting at the Louisville Boat Club at lunch. And they were clearly going to talk about business, and I said, the reporter said, what should I do? I said, go invite yourself to the meeting. So he walked into the boat club and sat down. It shook them. They didn't think that the reporter should be there, so they adjourned the meeting, got on a boat, the four of them, and went out into the middle of the Ohio River to talk about public business. We won that case. I actually argued that case against a former attorney general who was a partner in a major law firm, and that's the first case I argued at the Court of Appeals. Had a second case, very close to that, the same time period, against the Jefferson County School Board. Jefferson County School Board was represented by an attorney who I did really like. His name is Preston Young, was Preston Young. Very nice person. Bill Cox always said that he always hoped that everybody we sued was going to be represented by Preston Young, because he was not the best lawyer in this situation. So we sued the Jefferson County School Board for some things that were going on in closed session. And I called Preston and said, I want to take the deposition of each of the members of the school board. And he said, why? I said, to find out what they talked about, Preston. And he said, well, you don't have to do that. I'll just give you the tape recording. Well, the tape recording worked very well. We won that case. So for the first two, I was 2-0, and what was even more important was that the public agencies, both in Louisville and Jefferson County, but around the state, started to understand that there were consequences to violating the law, and that there were people out there who would hold their feet to the fire.
Mm-hmm. So let's fast forward a little bit. So, the law is being implemented. Agencies are starting to realize they have to follow it. But, it wasn't perfect, right? You already alluded to some changes that happened in the early 90s. First, why don't you talk about how that process came about, and then we can go through some of the specific changes in a minute.
The hero of this process is David Thompson, and he really is a hero. We had a couple cases that really created some problems for elected officials. David will remember names that I don't remember, but in the 1990 legislative session of the General Assembly, there were some very severe proposals to rewrite the open meetings and open records laws because the legislators were a little ticked off at some of the results we were getting. David said, don't rewrite it, create an interim committee that can meet and will report back for the 92 session. And on that committee, he suggested that the Press Association, the Kentucky Press, should be represented by 3 people. I was one. Stan McDonald from the Courier-Journal, a great reporter and great editor, was one. And Steve Lowry was one. For those of you who don't know or don't remember Steve Lowry, he was a great journalist. He was a super journalist from out in the state. He had a terrific run. He was a great friend of Kim's and mine, and we miss him. We miss him in his good days because he was terrific. So the 3 of us would meet, and there was some hostility in the room, and we were meeting with a bunch of legislators, and we'd go through the provisions of each law, and they'd say why, or are you having trouble with this? And we had firsthand information from Lowry, from McDonald, from me, talking about how we weren't able to get this or we weren't able to get that. One example in the open meetings law was the definition did not include joint agency planning commissions that might be there for 2 or 3 different counties, or health commissions. So we put in a much broader definition, and by the time we got to the end of the process, we were getting suggestions from the others in the committee on how to make it stronger. We probably met 6 or 7 times. We met in the Capitol, and we had 2 of the best newspaper people I had ever worked with involved in this exercise. One of the things I said to Mike, I mean, one of the big cases that we've won under open meetings and open records was the University of Louisville Foundation case. I don't think we would have won that case under the old definitions. But we broadened the definition so that it clearly included universities and related entities that might be formed. And we're still having trouble, by the way, with certain universities, including one that is fairly locally located, that believe that they can outsmart, that they can create a new entity and get around the law. I think they're mistaken, but it's an ongoing problem. We continue to see, it's really pretty interesting, we continue to see things now where new people are coming in and they think they have found a way. And Mike and I will talk, and Mike will say, what's this? And I said, well, I had a case like that. They brought it up in 1978, or they brought it up in 1984. There's really nothing new under the sun. It's just a matter of trying to confront. And we've been very successful doing that.
I would say one of the top lessons I've learned from my partnership with John, and there are many, but we can't stop fighting the battles we've already won, that you've already won, and the folks in this room. It's amazing, because you get new folks on the other side who come up with the same arguments and try them over and over and over again.
That's true, but we have an advantage. I have an advantage, which maybe I should say it, maybe I shouldn't, but I'm going to. There is nothing more fun in the practice of law to be arguing a case in the Court of Appeals, and they say, what about such and such a case? And you can say, that's my case, let me tell you all about it. That adds a level of persuasion that most lawyers don't have in these situations. So, and I know Mike runs into it too. I mean, there is nothing new. It just keeps happening over and over again. Maybe a slight variation, but there is nothing new under the sun.
So in the early 90s, you already touched, John, on one of the major changes, which was a much, much more detailed definition of what it means to be a public agency. You had these intergovernmental bodies much more detail too around, to your point about the universities. You added the provision that says, any entity whose members are appointed by somebody who is a public agency or a public official. And we dealt with that here at Western and some other places around, cabinets for university presidents or sort of informal advisory committees. Are they public agencies, and how to deal with that? So I think you all were pretty prescient back then in identifying some of those types of, quote, informal groups. But you also added, and talk to me a little bit about how this came about, the provision that said an agency violates the open meetings law if it holds a series of meetings with less than a quorum of a board. So what prompted that?
That was prompted by the behavior of the Jefferson County School Board, as were many of the provisions in the open records law back then. There was a practice which goes on today of making sure that the superintendent would call in one by one each member of the board, go over what was going to be talked about at the board, get his or her approval, and then the board meeting would last about 12 minutes. There'd be 3 things approved, and off they go. And I talked about it as a Jefferson County School Board amendment. We hadn't really talked about that, but that was one of the big changes. And we have, in fact, won some cases on that theory. It takes a little proof, but you'd be surprised how easy it is to get proof once you get some people sitting down and talking about how important they are. So and as Mike knows, I mean, one of the fun things I have learned to really enjoy the fact gathering process of the practice of law, not just the media law, but the whole practice of law. I love facts. I had a mentor of mine when I was a very young lawyer say to me, when you're in law school, all the facts are there because the cases are printed. He said, now you got the hard part, you got to make the facts. Well, that's both the hard part and the best part, because when you can make the facts and you know where you're going and the other side doesn't, you're in great shape. And you've had that experience.
We're going to talk a little bit about that here in a few minutes, but I think that is absolutely right. And I guess just briefly before we leave those changes, you all also in the 92 changes, I think this merits special attention. You changed, you repealed and totally replaced the existing rules around special meetings and, importantly, Attorney General appeals and judicial review. This sort of blends open meetings, open records, because those changes in 92, affected both laws. But talk to us a little bit about what changed with the judicial review and Attorney General provisions, and how that played together with the legal defense fund we have now, and how that all comes together.
The Attorney General review is extremely important. In those days, we thought, inaccurately, that we would always get a fair read, that we would usually get a fair read from the Attorney General. Cameron, in the last 4 years, has proved us entirely wrong. Just as an aside, his opinions ignored the law. And not just skirted it, they ignored the law. He was set on taking the open records law, I think mostly open records, I would say.
Yes.
And abolishing it. And we've been very active. Mike has been more so than I the last 4 years, very active on taking stuff that Cameron said going to court. What we added, I think we added this in 90 or 92, was that we added it, we were having a problem, and David will remember this, we were having a problem with getting an Attorney General's opinion. We've always had the Attorney General's opinion, or Attorney General would get. But we would get a decision from the Attorney General that says XYZ agency violated the law, and the agency would say, so what? What are you going to do about it? So in 90, we put in a penalty provision, a pretty darn strong penalty provision, as it turns out. And a provision that says that if the agency, if the losing party does not appeal within 30 days, it becomes the law of the case. That is, and all you have to do to enforce it is to file a lawsuit saying we filed a complaint with the Attorney General. The Attorney General said X, they didn't appeal, so X is the case. The best case that we've had, and we had some others that are going to be good cases too, but the best case we had dealt with the abuse cases well, Todd County was the one but the abuse cases really arose. We had sued the Cabinet for Health and Family Services, and there was a terrible situation in Todd County involving a little girl, a 9-year-old girl, I believe, who had been abused and was ultimately killed. And clearly, her family had been under the supervision of the Cabinet, and the Todd County, the newspaper filed an open records request asking for all public records. Public records, by the way, is a term of art in the statute. Asking for all public records relating to this young lady and how it was treated. And the Cabinet came back and said, we don't have any records. We don't have any records. We waited 30 days. They didn't do any. Oh, excuse me. We then filed an appeal to the Attorney General. Actually, the newspaper did, with the help of the Kentucky Press hotline. Filed an appeal to the Attorney General, and the Attorney General issued an opinion that, in essence, said you've got to have records. That cannot be the case. There got to be records. We're ruling against you, and you got to give up all the records. They did nothing. So I think literally on the 31st or 32nd or 33rd day after that decision, we filed a lawsuit. We already had what I call the big lawsuit going. So we filed a lawsuit and joined it with the big lawsuit that was filed by both the Courier Journal and the Herald Leader. And at the next hearing we had, unbeknownst, I didn't know this was going to happen, in front of Judge Shepard, the Cabinet came in and they had a stack of papers, maybe 6 inches worth of papers, and they held it up and they said to Judge Shepard, we want you to look at all these records and tell us which ones we have to produce. I basically went nuts at that point. And Judge Shepard knows I occasionally can get hard-spoken, not soft-spoken. And what I said was, this is incredible, Judge. They had told us, and apparently lied to us when they said they had no records. They told the Attorney General they had no records. They apparently lied to them. And now they're coming in with this 5 or 6 inches of paper, which I've never seen, and they're saying, take a look at it. Well, fine, take a look at it, but we're entitled to every piece of paper because of the law. Because the law says they didn't appeal, we're entitled to everything. And Judge Shepard, to his everlasting credit, took the weekend, read the whole thing, and put the entire record in the court record. So it was available to everybody in the state of Kentucky and elsewhere. That case, that particular case from Todd County, I think we used as Exhibit A on why we needed to get all of these abuse cases. Mike did part of the case with me toward the appellate part of it. And we ended up with a case that for the first time issued substantial penalties and legal fees. The Todd County Standard got back all of its attorney's fees, which it hadn't paid, because I actually had called and said, you don't owe us anything until we, that sounded like one of the TV lawyers, I guess. You don't owe us anything unless we get paid. I could have done that. Anyway, and so we got our attorney's fees, which I think on the Todd County Standard was something like $40,000. That's my recollection. But on the bigger case, in which the abuses by the Cabinet for Health and Family Services were many and very frustrating, the court awarded, I think in excess, attorney's fees and penalties in excess of $1.2 million or $1.3 million. There's an issue, by the way. There's a penalty in the open records law for $25 a day for each record. And so what counts as a record? And we said each page. And I can remember talking to Mike about this. We figured out if we got that, we would have a bigger budget the next year than the state of Kentucky. It went into the several billions. It was, so
Yeah.
we had a good time with that.
In the things never change, we have been having the same debate in our fight with the city of Louisville over the Explorer records, where they deleted 750,000 records of unknown number of pages, and it's been 5 years, and we figured out it was tens of billions of dollars in penalties should we be awarded those.
All I know is I said I can call the governor and tell him we'll help with the pensions. It was a huge award, and I think we both argued at the Court of Appeals, and it was a fun argument because it was an easy argument. And there's some stories about that which I won't tell, but we had practiced the case from the beginning, and we used the Todd County standard cases. It's amazing. I got asked to testify at the legislature. We used Todd County. It was a great, horrible thing. I mean, this little girl had been killed by her. It's convoluted in terms of what he was, but I called him a stepbrother. And it was, and the cabinet just refused to talk to us, refused to talk to anybody about it. And I went at it with Governor Steve Beshear, who for some reason decided he was going to be against transparency, and tried to do several things about it, including starting a study group, or whatever you call it, a reporting group for that the cabinet had to report to about these abuse cases, but he wanted to close the entire process so that you couldn't get anything about that. We had, and we were very successful in getting the legislature to turn against the governor on that. So it's
Those are now open meetings.
Those are all open, and their reports are open. Mm-hmm. Really important.
So we've sort of danced around this, but I just want to put a highlight on it. Talk a little bit about how the 92 changes to the open meetings and records law directly led to the Legal Defense Fund, and what you think that's meant for folks.
Well, I don't know that it directly led to it, but I will tell you that in having practiced and represented all of you guys for all this time, it's very hard to say 50 years, so all this time. I don't think there's any question that the existence of the Legal Defense Fund and the hotline have been extraordinarily important in the entire enforcement of not only media rights, but individual rights to get these records. For every case that we've had, there probably are dozens where we've answered a phone call, given some advice, and the records have been produced. For every case that we've had, one of the joys that I've had, and I know Mike has had too, is working with university students. I think we have a university press in Kentucky that is second to none, that is just terrific. Hard to convince people of that unless you've been here. But I will also tell you that we have a press association that's second to none. People tend not to believe it, but David will tell you how many times he gets a call from a press colleague from Nebraska or Georgia or someplace. What do you do about this? And David will say, well, we've had that in the law for the last 30 years. I mean, we've been way ahead, way ahead. And it's because we've had a press association and newspapers that have been willing to put their money where their mouth is. It's been an extraordinary experience for us.
So let's talk about a couple of the more recent open meetings and open courts issues that we've had to take through the courts. One notable one, of course, with John Nelson and the Advocate Messenger against the city of Danville. There's another one where you made some great facts in the discovery process.
There are a couple of cases with Nelson that I'd like to talk about. That is one with a good result and one with not such a good result. There have been disappointments, obviously. the Danville, I'm going to get my name screwed up, but the city council was essentially authorized the purchase of a building in downtown Danville that was going up for an auction. It would be put up on an auction, a final auction. And they authorized the purchase of it, so that at the end of the auction, without a meeting, without any notice, not any discussion, not any public discussion, the city of Danville ended up owning a $5 million building. I believe it's a $5 million building in Danville. And we decided, John Nelson decided he wanted to challenge it, so we challenged it. And it was one of the things that I think we put in 90, but I'm not 100% sure, was the definition of action taken.
Yep.
Another little thing about action taken. Well, action taken doesn't necessarily mean a vote. It doesn't necessarily mean, it just means a commitment, however you get there. And clearly the city council, Danville had committed to buying a building without an open, without any meeting whatsoever. And we had, I actually wrote a letter, something I've done once, this is the only time I've ever done it. I wrote a letter to the lawyer for the city council saying, here's what's going to happen. And we went through it. I mean, I went through it point by point, and that's what happened. It didn't take a genius. I mean, I was pretty sure what was going to happen. But he fought and fought and fought. Well, we ended up winning that. We did not get attorney's fees, which we should have gotten, but we got everything but attorney's fees. And I think the remarkable thing about that case, it's amazing how often it happens, is that the building turned out to be a lemon. They didn't have any use for it. They ended up holding, was it $5 million, John? $5 million building, that if they had an open meeting, they might have had some people come in and saying, why are you doing this? We don't need it. But they didn't do that. There's a lesson in politics there, a lesson in public policy. But they were determined to keep it secret.
Yeah, I was going to say on that case, it's the perfect example, I think, of why the procedures really matter, because when the new mayor took over, he wrote in the paper, an op-ed, and he said, you know, we're a government agency, so owning commercial real estate like this doesn't make sense because we don't have taxes to deduct. And he's like, and oh, by the way, it's going to cost multi-million dollars to renovate this for the purpose we need it. He's like, if we would have had this debate in public, somebody could have pointed that out. But you're right, their attorneys were dug in because they had given them the advice it was okay to do this.
Right.
And
the real problem was that under our theory, which turned out to be the law, the city could not bid at this type of auction because it had to have approval of city council for a particular the governing agency for the final purchase price, and that struck some people as being a problem. I mean, our answer was there are lots of things a public agency can't do that private people can do. And so we won the case, but I think that's why we lost the attorney's fees. Plus we have some very old-fashioned people in the Kentucky Supreme.
well, yes, that was true. And you know, bad facts, bad law kind of situation. But I think for the city, it didn't help that they not only had this secret meeting to decide, but then hired an agent to hide their involvement and kept everything clandestine. And it wasn't until they actually owned this thing that they said, guess what, that was us. I don't think that sat very well with the courts.
They also weren't getting great legal advice, did they?
Well, that's true.
One of the members of the city council testified that they made a commitment to vote this way.
Yeah, we reached a consensus.
We
It's
reached
like,
a consensus.
that's what the law says action means.
If he had read the law, he used exactly the words that were used in the law to say they made a decision. Some cases are easier than others, and that was fun. The other case I want to talk about, which is really goes to open courts, but
Yeah, please.
But I want to talk about it. Is the KPA was involved through John Nelson to try to open up juvenile courts and family courts because of what appears to be the absolute message of the statute that they are closed in certain respects. again, without going into detail, if you read the United States Supreme Court cases dealing with open courts, the language is magnificent. It's great language about why you have to have open courts, why you need openness, why you need public the public participation, and so on and so forth. We did something that I think raised the hackles of a lot of people in the state of Kentucky. We were trying to open this up. For those of you who have not been involved, and I have not been involved, other than suing on juvenile courts on occasion, but due process is left behind when you close court proceedings. It just is. And it happens a lot today in family court. I guarantee you it happens in juvenile court. It just is. It should be open with some exceptions. We lost that case in the Sixth Circuit. Got a very bad panel, and we lost that case. We've been able to use that case to open up certain juvenile court proceedings of a serious note in Jefferson County. But that's one of the cases, one of the main cases I really regret. We should have won it. We had good arguments, and I got cussed out by the clerk for the Supreme Court after I filed it. She said, she was really mad at me. She said, it has to be closed. Well, anytime somebody says it has to be closed, a good news person will say, why? What is it that says it has to be closed? That's the reason it should be open. So that's one that I remain very disappointed about.
That's a good segue into some more open court issues. I know we wanted to just touch on those. They're not directly governed by the open meetings law, but I think they're a close cousin. So, you know, we've had some recent cases, but take us back to the Pierce case. Tell us kind of, you know, how you all blazed that trail to make that good law here in Kentucky.
Well, Kim's here, and Kim was one of the blazers. What happened was in the early 80s, it actually started in 1980 with the case involving anyway, a case out of the Supreme Court dealing with open courts. And that's when we started, we as the press in Kentucky, trying to open up courts that were closing when they shouldn't have been closed. So we had a case involving Judge Pierce in Louisville, in Jefferson County. She's deceased. She was a very nice person. That's all I'll say about her legal. But she was very nice. She waved to us when walking in the park. Judge Pierce had a case that was where they were closing probably Boy Deer. I'm not 100% sure what it was. But in those days, we didn't know how to intervene. We didn't know how to do it. So we just basically barged in, knocked on the door and said, we're here. That particular day with that particular case, that was Kim. We ended up at the Supreme Court of Kentucky, and they said, here's the process, which is really important. The process, and it's called a mandamus process. It's expedited, and in Kentucky, it's really quick. It was a great win for the press and for the people of Kentucky. They criticized the lawyer who knocked on the door. And I can say it wasn't me, Judge. It was Kim. Anyway, so we got that decision, and then within a couple of months, I get a call that Judge Pierce has a case that she's closing, that she closed part of the case on. And I actually did not know what to do. I knew what to do, but I didn't know what to do quickly. This was ongoing. And I walked over to the Louisville office of the Court of Appeals, which was Judge McDonald, who's since died, a really good judge. And I told him about it. He says, I know what to do. He picked up the phone and he called the court. And the bailiff answered him. Well, I'm sitting there, and the bailiff answered the phone. And he said, I want to talk to Judge Pierce. And he said, you can't. She's in a closed session. And he said, Mr. Bailiff, either you're going to jail or the judge is going to go to jail. It's your choice. The judge came to the phone. And under the proceeding, which was really truncated, because basically what Judge McDonald said was, I want everything to stop now. I want Mr. Flyshaker to get a transcript of the proceedings tomorrow morning, and then we'll see where we're going. So what had happened was, this was a trial of a lawyer who was involved in fake marriages to allow, I'm not sure where they were from, but to allow people to become citizens or residents of the United States without going through the proper procedures. And he was getting paid a considerable amount of money. And he was also, he and a buddy were also having social relationships with some of the women who had been hired to perform this function. And there was testimony, open court, testimony about how the two guys would take two women and they go to a motel and they get a room with two beds, and they'd each get in bed with the woman, and they'd switch partners, and then all four of them would get together, and so on and so whatever. Totally open. Nobody said a word. And then the guy was asked, what was your arrangement with Mr. Smith? And he said, well, that's very private. I consider that very personal information. We won that case. We won that case. But it's amazing how many, Kentucky courts have always been very responsive to open courts. We've got good law here, really good law. And the other case I will talk about, which was an open meetings case, involved the University of Kentucky that had been charged by the NCAA with violations of what many of you will remember as the $1,000 handshake case. And they had engaged in a long, drawn-out investigation on their own, and they were getting ready to file a response to the NCAA. But it had to be approved, they said, by the Board of Trustees, and they announced it was going to be in closed session. So we, and I think it included the Herald Leader, I think it was the Herald Leader and the Courier Journal, filed suit and asked for a preliminary injunction that they're going to have a meeting to approve this that has to be an open meeting. And we wanted it. It was a 9 o'clock hearing in Circuit Court in Lexington, and we won. Then immediately after that, Kim and a lawyer for UK got on what I'm told was a UK helicopter and flew to Pikeville for a hearing about the FERPA, the student rights issues about one of the ball players and some of his academic performances or whatever you want to call what he did. And Kim handled that, and I got ready for the Court of Appeals hearing. Plus, I didn't want to get off the helicopter. Anyway, so we then had the second hearing. Kim had the second hearing. I had the third hearing about 6 o'clock at night with the Court of Appeals, and we won that. And as we were about ready to finish, the judge on the Court of Appeals said, I've alerted the Supreme Court of Kentucky that there might be an appeal. And the UK lawyer, a very nice guy, I mean that sincerely, said, I wasn't going to appeal till he told me I should, so he appealed it. And we ended up arguing that in front of a judge, later to be the Chief Justice, Lambert, at about midnight, I think, maybe 11 o'clock at night, in the Supreme Court of Kentucky, and we lost. We lost that. We got home about 2 o'clock in the morning. We'd left it. So we did all 3 levels of the Kentucky court system in 20 hours. But we lost. But then we won because the trustees said there's been too much hullabaloo about this anyway. We're not going to have a meeting. We'll just send it off. So they sent it off, and that resulted in another lawsuit. We said, okay, you've done your final work on this response. We want to see the response to the NCAA complaint. That went all the way to the Kentucky Supreme Court. I argued that case at the Kentucky, at UK Law School. I thought that was sort of interesting. Started out the case with, they all asked us to meet in private for a set. Can the lawyers come back and meet with the justices? We did, and the Chief Justice said, we may have a problem. We all get free tickets to UK basketball games. Well, we had done it all. We had done all of this, and so I said, okay, we trust you. And then I turned to Justice Leibson, who I've known forever, and said, can I have your tickets to the UK UW game? He did not answer. Anyway, so we won that case, and there's and that case, which we all thought was just sort of on its own, has turned out to be a remarkably important case in Kentucky. And one of the things that it says, and it says it almost point blank, UK was saying, NCAA doesn't want us to do this. They want it to be secret, and they do. It's a secret organization. They want it to be secret, and we have to abide by them. And there's a paragraph in the complaint that says, we don't care what the NCAA wants. We're dealing with the law of Kentucky. That has come up a lot because of these deals that these agencies make about we can't do this with them because they want it to be secret. It's great language.
It is.
It's been a terrific result.
As an aside on the hotline, we take calls from a lot of folks in this room and others every day, and I think the piece of advice I have to give just about more than any other is about that very case, about how once something is over, it's no longer preliminary. That case says point blank, and the fact that it's being investigated by some other agency is irrelevant. If the Kentucky agency has done its work on it, it's open. The Bevin administration lost a couple of records cases about stuff they sent in on their health waiver to the federal government. And the courts have said, yep, if you submitted your waiver application, you're done. It doesn't matter if they're not done with their work. The citizens are entitled to see what you're asking for. So that case continues to be extremely important.
Yeah, and it was fun argument in the UK. We had a good time.
I bet it was. I want to, coming back to the theme, you got to keep fighting the fights you've already won. I want to put in a plug because recently we saw a situation just like Piers. It was in Louisville, where the judge presiding over the Brett Hankinson federal trial, one of the officers accused in the Breonna Taylor case, had voir dire in chambers entirely outside the public view, like 100% of voir dire. And we didn't have there were a number of outlets covering it, and we didn't get a single call about that. So we're partially dependent on you all to, bring that stuff to our attention so we can rush in there. And, if you have any questions, call the hotline. That's what we're here for. And that's, that could have been handled quickly and easily. And, that case ended in a mistrial with a hung jury. And, I'm not saying it would have been different if voir dire would have been public, but sure want to know what they asked the jurors.
There was a great case in Harlan, Kentucky, at a time when the Harlan newspaper was owned by the New York Times. And I got a call, ostensibly through the hotline, about a big murder trial that was going on in Harlan, and they were doing individual voir dire sequestered, secret. Would you go down there and intervene and make a motion for us? So I did. I went down there, and I was sitting next to the Commonwealth attorney, who later turned out to be, became the judge. Really good judge. And this was a case in which the defendant was charged with sexually abusing and then murdering a young, I think teenage, but I'm not sure, girl, down by the railroad tracks. I mean, it's really a horrible crime. And they brought him in. And he was a mountain man. He had a big beard, he was a big guy. And I turned to the Commonwealth attorney and I said, what are we doing here? And he said, what do you mean it's a trial? I said, but look at him, he's gotta be guilty. So I made my speech, my motion, and as I said before, there is terrific flag waving language in the open meetings, the open court cases from the Supreme Court of Kentucky. It's terrific stuff. And for the first and only time, and the courtroom was packed, it was a big old-fashioned courtroom, it was packed, and I made my speech, and I got a standing ovation. and the Commonwealth attorney turned with a smile and said, I think you're going to win this one. So I mean, but it was, it brings up another point that I want to make, and that is, for most of the time that I've been practicing this law in Kentucky, the state of Kentucky has been a great place to practice First Amendment law. It's been a great place. Probably a lot of things go into it, a lot of libertarian, keep the government off my back, you can't tell me what to do. I learned a lot when I went to Harlem. They were doing individual voir dire in secret potential jury members, and they thought they were in the trap. All of them came, not all of them, most of them came up and thanked me for opening up because they felt they were being interrogated and that they didn't like being treated like a member of the criminal conspiracy. I think openness is not just with courts, but with all agencies. I wish public officials would understand how much it helps a public understanding of what's going on and a public buy-in on what's going on with public decisions. But that's a hard lesson to learn, apparently.
Here, here.